Peace, family. Hope all is well. And good morning, Grown Academy. All right. Today, we're diving into a powerful tool, for asset protection and estate planning, using a quitclaim deed to transfer a property into a trust. All right. This is a practical and strategic way to protect your property while avoiding certain pitfalls, like triggering a due on sale clause, all right, which is in your mortgage. We're going to break it down step by step. And before we get to it, remember, we have a template for your quitclaim deed available on Patreon for free. The link is in the bio. Sounds great, Coach. I've heard about the quitclaim deeds, but wasn't sure how they work with trust. No problem. By the end of this session, you will not only understand how to use the quitclaim deed, but also how to handle the process without causing unnecessary complications. First, let's clarify what a quitclaim deed does. Okay, as you can see here, a quitclaim deed transfers ownership of property from one party to another without guaranteeing a clear title. It's commonly used for transferring property to a trust, family or intra-business transfers, as well as correcting title errors. See, when you're transferring property to a trust, the quitclaim deed essentially sells the property to the trust, making the trust the new owner. The best part, you don't necessarily need to record the deed immediately, which helps you avoid triggering the due on sale clause in your mortgage. So the trust owns the property as soon as the quitclaim deed is signed, even if it's not recorded? Exactly. Recording the deed is about public notice, not the legality of the transfer. Next, you'll need to draft the quitclaim, okay? Here's what you need to go into it. All right. I have it listed from number 1 all the way to 6. And I'm just going to give you this information. Okay. The grantor's information is the first thing you need on there, which is number 1. That's you, the current owner of the property. Second, your guarantee information, the name of your trust and its trustees. For example, your name as the trustee of the trust and the date. Okay. And 3, all right, the legal description. This is the official description of the property, not just the address. You'll find it in the current deed or from the county records office, the county recorder's office. Okay. Fourth, consideration amount. A normal amount like $10 and other valuable consideration is typical. Okay. Number 5, the no warranty clause. This makes it clear that the no guarantees about the property's title are being made. And 6, okay, signature and notary section. The grantor must sign the deed in front of the notary. Can I use a template for this? Yes, of course. Templates are a great starting point, but make sure to customize them for your specific situation. Double check the legal description and trust details, okay? We do have the template for you available. The link is in my bio here for free on my Patreon. All you have to do is become a member. Once you become a member and sign up in the Patreon as a Grown Academy member, all right, you'll have access to it as well as this presentation. Moving forward, after drafting, the grantor, that's you, okay, must sign the deed in front of the notary. And here's how, okay? First, bring the unsigned deed to the notary public. Second, provide a valid ID for verification. 3, sign the deed in the notary's presence. And 4, the notary will complete the acknowledgement section, sign, and add their seal. Well, does it matter who the notary is? Yes. Okay. The notary should be impartial. Avoid using immediate family members, as many states prohibit this. Which brings me to my next point, deciding whether to record the deed. Here's the key to that decision, okay, whether or not to record the deed. Recording provides public notice of the transfer, but it may also alert your lender, triggering the due on sale clause. Now, if the property is transferred into a revocable living trust that we teach here at the Grown Academy for you guys to do, okay, the Garn St. Germain Act protects you from triggering this clause as long as you remain a beneficiary of the trust. Okay. Second, the property is your primary residence. And lastly, loan payments are kept current. Okay. So if I don't record the deed, the transfer is still valid, right? Jay, that's correct. The trust owns the property as soon as the deed is signed and notarized. Keep the deed in your trust book along with the trust agreement as proof of ownership. Okay. Well, what happens if someone sues me or tries to claim the property? If someone sues you, you can present your trust book, including the quitclaim deed, all right, as evidence of the transfer. Courts will recognize the deed as valid, even if it's not recorded, provided it's properly executed. Okay. And what about refinancing or selling the property? If you refinance or sell, you may need to transfer the property back into your name and record the deed at that time. This can usually be done without triggering any issues, as long as the transfer is transparent and properly documented. Brings me to my next point to ensure that everything runs smoothly, okay? First, keep the loan current. Make timely payments to avoid raising lender concerns, okay? You got to play the game properly. Second, all right, maintain accurate records. Store the deed, trust agreement, and related documents securely, okay? And thirdly, consult professionals. If you're ever unsure, work with a real estate attorney to review your process. Got it, coach. This makes the process seem much less intimidating. It's all about understanding the steps and your rights. With attention to detail, you can use the quitclaim deed to protect your property and avoid unnecessary complications. Great work today. Final questions before we move on. Just one. How do I know if my trust qualifies for the Garn St. Germain protections? That's a great question. A revocable living trust that lists you as the primary beneficiary generally qualifies. Okay? Double check with an attorney to confirm, especially if the trust has unique provisions. However, if you're with the Grown Academy, you're safe. Thanks, coach. I'm ready to put this into action. You're welcome. Now go out there and get those assets. Everyone else out there who's not enrolled in the Grown Academy just yet, the link is in my bio here on TikTok, okay? You click on that, become a free member on Patreon to go through materials such as this with the presentation, the templates, and the scripts to go along with it so that you can build up yourself in these methods and master them so that you can attain these assets, all right? Now, I have to put this disclaimer here. It's something that I must do. This is not financial advice. This is not legal advice. If you're seeking legal or financial advice, I highly encourage you to seek legal or financial counsel immediately. Well, no, I hope this helps. And I love you guys. Peace.